Hello and welcome to this episode of Law for Lawmakers. I'm Fiona Rutherford, Chief Executive of Justice, the UK's law reform and human rights charity, working to create a fair justice system within everyone's reach. This podcast is based on our Law for Lawmakers guide, which helps repair the cracks in the UK's political foundations by giving every MP the tools they need to act as custodians of our democracy. The guide explains the key legal and constitutional principles that underpin good lawmaking, helping parliamentarians and their staff review new laws, table amendments to ensure bills are written well, support their constituents and hold power to account. But this podcast isn't just for parliamentarians. It's for anyone who cares about how rights are protected, how public bodies exercise power, and how our laws shape the everyday lives of people across the country. Each episode brings together leading voices from law, politics and public life to explore the principles that underpin our democracy and to look at Parliament's role in upholding them. In this episode, we're looking at the rule of law from a different vantage point, its importance to the health of the UK economy and our reputation as a global centre for business, investment and dispute resolution. And I'm delighted to be joined today by someone who works at the intersection of this triangulate every day. Andrew Denny is a partner at A&O Shearman, where he heads the UK Public Law Group and helped establish the firm's global business and human rights practice. Andrew is a highly respected litigator and has represented clients in some of the most complex high-stakes cases before the UK's senior courts, and routinely handling cross-border disputes involving jurisdictional challenges, anti-suit injunctions and parallel proceedings across multiple jurisdictions. Alongside his commercial practice, Andrew has a strong pro bono record. He's acted for NGOs in human rights challenges against the UK government, reflecting his long-standing commitment to access to justice and the principle of the rule of law as a public good. A&O Shearman supported the development of Law for Lawmakers, and Andrew brings a valuable perspective on why clear legal frameworks, independent courts and predictable government decision-making are not only constitutional elements but vital foundations for economic prosperity. Andrew, it's an absolute pleasure to have you with us today.
It's a pleasure to be here, Fiona.
So we're going to dive straight in and talk about the rule of law and the economy. And as I've said, you work at the intersection between public law and complex commercial disputes. And we often hear that one of the greatest attributes to the rule of law is legal certainty, particularly in the commercial context. In practical terms, though, how does predictability in our legal system support business confidence and give that certainty in relation to investments? And why is the rule of law so fundamental to the UK economy and its global competitiveness?
Well, you'll hear from government a lot that they're very keen, obviously, to have international investment into the UK economy to help growth. Growth at the moment is one of the biggest issues facing that economy, and having that investment is absolutely key. And we act for those international players who are looking to invest in the UK. And if you ask them, what are they looking for in a legal framework, in a wider governmental framework? They're looking for that word certainty, they're looking for consistency, and they're looking for a level playing field. And I think those are really some of the key things that a strong rule of law can bring. If they invest in the UK, they want to know that their investment 5 years down the line will be subject, not exactly the same rules, but consistent rules that are applied in a fair and non-discriminatory way. That can make the difference. Knowing that, having that respect for the rule of law can make the difference between whether a party invests in the UK or invests somewhere else. And given the need for international investment to encourage growth, I think the rule of law in that respect is absolutely crucial.
And so conversely, what kinds of risks do business face when the legal framework becomes unclear, whether it's because of rushed legislation, over broad powers or constitutional instability?
Well, I think it's really obviously it's the converse. It's the lack of certainty that, say, take rush legislation can bring. If legislation is introduced which hasn't been thought through properly, which hasn't been thoroughly tested by parliamentarians who are very much focused on, how is this going to work, then you end up with legislation which is unclear, which may be applied in an inconsistent manner. And that level of uncertainty is the sort of thing that does cause businesses to have second thoughts about their investment decisions. Will they continue to invest in a particular business? Will they try and add a further production line in that factory that they've got in the Midlands? The way that legislation is applied is absolutely key to that, and the way that it's drafted is key to that.
You litigate cases. I'm going to move on to when drafting sometimes doesn't quite work or the outcome is not achieved throughout the parliamentary process. You litigate cases that bring commercial actors into contact with public bodies, often known as judicial review. How does that judicial review safeguard, or that process safeguard, the stability and fairness that you've talked about and that businesses rely on?
Well, so many of the businesses we act for act in regulated sectors, and they compete with each other in a regulated framework. And it's the regulator that will exercise powers in that regulated framework. And we know from experience that the regulators, when they're making their decisions, an important safeguard, an important factor they will take into account is the risk of being judicially reviewed, the risk that they will know that they have to exercise their powers in a way which is consistent, which is consistent with the legislation first and foremost, but is fair and is non-discriminatory, because they know that in the commercial sphere, that well-funded companies in their sector will challenge them by way of judicial review if they step outside the bounds. So judicial review plays an absolutely key role in ensuring that regulated parties and indeed regulators and indeed the government don't step outside the bounds of their powers when acting in that sphere.
We've often heard judicial review, the sort of flip side of it, of being an obstructive tool. From your experience, how do clients actually view it? Do they see it as a barrier or a necessary protection that ensures fair and lawful decision making, or something else?
It very much depends on the client. And in all honesty, we do have clients, particularly who are developing large construction projects which require to go through the planning process, environmental permitting, who, in all honesty, can get frustrated by judicial review and the delays that it can cause. But to flip back to the regulated sector, I think regulated clients in particular see judicial review as absolutely key to protect themselves from what they may perceive to be regulatory overreach. So it does very much depend on the client.
Which side of the process we're sitting on.
Exactly.
I've mentioned that you do a lot of cross-border disputes. I'd like to talk about that and the UK's reputation, because that's, I think, underpins some of that global competitiveness and the certainty that attract various different businesses to the UK. And you routinely act in these sorts of disputes, which I'm sure frequently involve challenges which are based on jurisdiction. What does this international what does your international work reveal about the importance of the UK maintaining that strong, independent, rules-based system?
Well, the starting point for it all is to appreciate that commercial parties, big international commercial parties, have a choice of what law and what jurisdiction will apply to their contracts. And that it's absolutely crucial to understand that. And a number of them will choose English law. And we frequently, if you look at the statistics before our commercial court, I don't know what the current statistics are, but a large proportion of the parties before the commercial court at the moment who've chosen the English courts to resolve their disputes will not be, neither of them will be from the UK. And the reason they make those choices is because of the reputation of the English courts and English law as stable, predictable, independent, and a very good way to resolve disputes. So if we go right back to what choice they're making when they're including in their contracts, they're choosing English law and English jurisdiction for those reasons. And the rule of law is absolutely crucial to that, the fact that the UK has got a very strong rule of law reputation. And that then, of course, it's why I'm here, that it drives the legal industry in the UK. So that's the first aspect of it, the fact that people are choosing English law and English jurisdiction because of the UK's strong reputation in the rule of law front. But then when we come to jurisdictional disputes, it gets quite interesting because frequently there will be a fight over what is the most appropriate and the most appropriate forum to resolve these disputes. And there we get into sometimes quite an awkward comparison between different judicial systems as to where will the dispute most fairly be resolved. And again, the English court comes out well from that because of its independence and because it's considered to be a very strong and rigorous judicial system. And that is, if you come back to the need for growth in the economy and where this economy does well, it's in services. And if we can continue to export our services, and one of those services being legal services, that will aid the growth of the economy. And that all comes back to the strength of the rule of law and the strength of the judicial system in this country.
It's amazing. When we started working on the rule of law, you can quite quickly get to the importance of fairness and certainty when it comes to more access to justice sort of elements. But the value and benefit to the legal economy is something that I know the Master of the Rolls, Sir Geoffrey Voss, is one of the biggest advocates for, the billions, literally, of money that is brought in as a result of the cases and the disputes, etc., that you've just talked through. Supporting good lawmaking. So moving on to the way in which laws are created, which is at the very heart of the Law for Lawmakers guide that A&O Shearman has so brilliantly supported. From your perspective, why is it so important that parliamentarians grasp the basic principles of good lawmaking? It might be an obvious question, but
I think it relates back to that initial starting point of certainty. And my day job frequently involves reviewing legislation and trying to work out what it means. It's as basic as that. And I think part of the problem is when you're making law, if it's rushed, the drafting of that legislation and in the way that it's put together, if it's not tight, if it's not clear, leads to that lack of certainty. And I worry in particular, and I think this is increasingly a feature of the Commons, is there's just a lack of time to go through that level of scrutiny. And there's obviously a strong debate to be had about the continuing role of the House of Lords. But I know that our clients value the level of scrutiny that the Lords can give to legislation and the level of expertise and, to a certain extent, political independence that they bring to that exercise. And that expertise, I think, can frequently lead to better drafted legislation, which leads to a greater degree of certainty. So if I was to have advice for an MP, I would say try and take a step back and read this legislation and say, firstly, does it make sense? Is it clear? How can we improve it? And are there unintended consequences about some of these provisions? And just I hope that we can give our MPs the time to do that, because that's the most crucial part of their job.
On to access to justice and the fairness or systemic fairness. You've acted, as I've mentioned, pro bono for a number of NGOs on human rights challenges against the government. Can you tell me a little bit about one or two of your most memorable cases?
I think the most memorable one was a case called Limba, where we intervened on behalf of an immigration detention charity in a case that went all the way to the Supreme Court. And it concerned a policy of the Home Office, a written policy saying that its default position with immigration detainees is that they would be released pending deportation. And it later turned out that their actual unwritten policy was to detain pending deportation. So they were running a secret policy which completely conflicted with their stated written policy. And oddly enough, the Supreme Court thought that was not a good idea. And that did lead to some of the most awkward moments I've ever seen in court, when very senior barrister acting for the government basically had to explain to the court why this hidden policy had been hidden. And it led to some quite interesting exchanges. But again, that it's actually a perfect encapsulated example of the rule of law. And one of the key aspects of the rule of law is if you're going to have a policy and you're going to follow a policy as a government body, you've got to publicise it, and you've got to stick to it unless there's good reason. People should know where they stand. And they should know if you've got a policy, that's the approach that's going to be applied to you. You can't have this secret policy behind the scenes, and that, of course, was struck down.
And the Supreme Court, I mean, it's mentioned a lot in the press, but in the reality, it doesn't handle that many cases. I mean,
No.
how many cases have you been involved in at the Supreme Court?
5 or 6, I think.
Okay, yeah. So in a career,
it's not huge numbers.
No.
But when you get there and you see the level of focus that some of the best judicial minds in the country can apply to what sometimes are very, very narrow points, it's really impressive.
Yeah.
And again, it comes back to the strength of the judiciary in this country, and something we should be incredibly proud of, but it's something we should cherish more. And I worry that people don't appreciate the level of contribution it makes, both to the economy, but also Britain's reputation worldwide, I think.
Looking ahead, and we're going to wrap up with this last question. What gives you confidence about the future of the rule of law as being one of the UK's greatest strengths, greatest assets?
I worry, actually. I'm not sure I am confident. I worry about the level of attacks on judges. I worry that there's so much debate about what the rule of law is that people aren't focusing on what should be common ground about the rule of law. And I also worry that the general population don't understand the importance of it, and that it is to a certain extent slipping from our grasp. And that, I think, is a concern, both for our clients, for all the reasons I've already explained, but also for everybody as individuals, because the rule of law is absolutely vital to our personal freedom and our values as a society.
Thank you, Andrew, for joining us today. We're really grateful for you sharing your time, your insights into why the rule of law really matters, not just constitutionally, but economically, for businesses, for investors, and of course for the UK's place in the world. Thank you for listening to Law for Lawmakers. We designed this guide not just for parliamentarians, but anyone who cares about the rule of law, whatever your background. To learn more about our work and to access the guide, please visit www.justice.org.uk. And if you found this episode insightful, do like, subscribe and share it with family, friends, colleagues, anyone who cares about the justice system working properly. I look forward to speaking to you on the next episode.